As the U.S. presses for a ceasefire in Gaza and world leaders search for moderate Palestinian leadership, a legal case has surfaced in American courts, one that may throw a wrench into these efforts. At its core, the case is about justice for American victims of terrorism. But the plaintiffs also have a message, a stark reminder that the Palestinian Authority continues to pay convicted terrorists for murdering civilians, and that it is no partner for peace. This case is also just one example of many now where law is being used to correct public narratives, to seek justice for victims, and to push back against the rising tide of anti-Jewish violence, discrimination, and even support for terrorism in America. Today, we go inside that legal fight to explore the surprising ways that the courts are becoming a front line in defending Jewish life and values. I'm Aylana Meisel, and this is Basic Law. Joining me is Rabbi Dr. Mark Goldfeder, founder of the National Jewish Advocacy Center, one of the key figures driving these landmark legal battles. Mark, thank you so much for being here.
Thank you for having me.
So let's start. We're going to talk about a bunch of different kinds of cases today and the ways in which, hopefully, they can advance the protection of Jews, of Israelis. We've talked offline about some innovative cases that you've been bringing recently. I do want to start first, though, with this case on what you allege is still continued pay for slay. What's happening there?
Sure. What makes this lawsuit very important and very timely is it comes just weeks after several countries formally recognized a Palestinian state, and it was purportedly conditioned on governance reforms and a commitment to combating incitement and violent extremism. And it also comes right as the world is debating the best ways to implement the Trump plan for Middle East peace, which also envisions a future governance role for the Palestinian Authority, again, based on those same assurances of sincere rehabilitation. And our lawsuit alleges that those promises are hollow and that if we're not very careful, even that ambitious deal is going to accidentally concretize some of the very pathologies that we are trying to get rid of. Again, despite its public pledges to these Western governments, the PA and its umbrella organization, the PLO, are continuing to disperse monthly stipends to terrorists and their families, and the payments, again, increase with the severity of the crime and the length of the prison sentence. So they're literally incentivizing more murder. Now, our lead plaintiff in this case is Stuart Force. Stuart Force is the father of Taylor Force. He was a young American Iraq War veteran, West Point graduate, who happened to be visiting Israel in 2016 when he was stabbed to death by a Palestinian terrorist. And that Palestinian terrorist and their family soon began receiving stipends. When Congress heard about that, they were rightfully sickened, and they responded to the killing of Taylor Force by passing the bipartisan, by the way, Taylor Force Act in 2018, cutting off U.S. aid until these payments stop. But they recognized, even then, Congress recognized that the Palestinian Authority might persist anyway. They might try and do the subtle shell games that they've been engaging in. And so Congress enacted another law called the Promoting Security and Justice for Victims of Terrorism Act, PSJVTA, in 2019 to ensure that by continuing to pay terrorists to kill Americans, the PA and the PLO would thereby be consenting to U.S. jurisdiction. Just this past April, the Supreme Court upheld that framework in a case called Fold versus PLO. They called the fight against terrorism an urgent objective of the highest order. So post that decision, the full decision, this suit invokes that PSJVTA law to finally impose financial consequences on the PA and the PLO for incentivizing and subsidizing
We
murder.
actually had an episode covering the Fold case the week that it was issued. Very, very moving development. I want to just understand a little more closely what the actual facts of the case are. First of all, because the numbers on pay for slay in general, I think, are always important to emphasize. And secondly, there was coverage only late September about the fact that, at least officially, pay for slay has been scrapped, and that the Palestinian Authority has moved to kind of a new welfare scheme that's entirely based on financial need and not, how and how many people you've killed, which is nice.
It would be nice if it was true, but this is not the first time that they have done this. This is not the first time that they have played this game. Roughly 6 to 8% of their actual budget goes to paying this quote unquote martyrs fund. And every single time that the Western world pushes back, again, they shift the name of the office, but it's the same office, it's the same people, it's the same amounts going to the same people, oftentimes from the same ATM. Our experts on the ground have confirmed that even now the payments are still being made regularly. And again, one of the interesting things you'll notice is that there have not been mass riots and protests in the West Bank about the stopping of these payments. If they actually had stopped, I guarantee that there would be mass protests calling for
So
their
where does the case
reinstatement.
stand now? Like what stage are we at?
We just filed. We're waiting for the Palestinian Authority to appear by counsel, and then hopefully we're
All
ready to
right.
move forward.
So you brought this in part under the ATA, right? Could you tell us a little bit
Mhm.
more about that law? And I know you have other cases relating to it and trying to develop it in different ways and making sure that it covers a host of different kinds of possible support for terrorism. So if we could just start out learning a bit more about the statute and then hear more about these important cases. Let's go.
Sure. The Anti Terrorism Act, 18 U.S.C. Section 233(1), is a series of statutes that were enacted to give American victims of international terrorism the ability to seek civil remedies and to strengthen the criminal penalties for terrorist acts. It allows U.S. nationals injured by reason of an act of international terrorism to bring a civil lawsuit in federal court, and they recover treble damages. That's triple the actual damages, attorney's fees, and other costs. And what was also important is that Congress decided to add an aiding or abetting clause as well, which means that if you aid or abet international terror, you can also be liable. And that's where we have been working. So I will tell you a little bit of the background about what got us into this space. I don't know if you and your listeners saw this, but literally on the afternoon of October 7th, Students for Justice in Palestine and some of their related organizations released a toolkit, and this toolkit was a series of Hamas propaganda and related charges, asking people to go out and do things, to protest, to hold a day of resistance, literally in collaboration with Hamas's Day of Rage. And it said some incredible things in that toolkit. It said, for example, we are not just part of this movement. We are this. We are not just in solidarity with this movement. I'm sorry. We are part of this movement. We are all operating under a unified command. They literally identify themselves as being members of Hamas. And the way that this case developed, it's a little bit funny, was I made the very sad mistake of getting active on Twitter right around October 7th. It was probably an error on my part, but I was still learning how it works. And so when I saw that, I actually tweeted, Dear SJP, cosplaying as terrorists is actually a crime under this section. And the tweet went a little bit viral, and I ended up doing an article for CNN expanding on that. And then a couple of states reached out and said, is this true? Among them, the state of Florida. And we wrote a memo. And shortly thereafter, the state of Florida actually deactivated all of the SJPs in their state, which was great because it provided an excellent test case for us to see what the responses would be. And the responses were threefold. One response, I believe, was the ACLU, was that, well, this is not support for terrorism because there's no money changing hands. Well, that's just wrong. The Supreme Court in Holder versus Humanitarian Law made it clear that even speech, if it's done in coordination with a foreign terrorist organization, can be considered a material support. Next came from two different law firms. I believe it was Palestine Legal and the Center for Constitutional Rights. One of them argued and said, well, these laws are Islamophobic. Okay, that sounds like an admission of guilt to me. And if you want to argue about the basis of the law, holding them accountable, happy to do that at the appellate level. And the last response was, well, you're wrong because that toolkit came from National Students for Justice in Palestine, and these are just local chapters. To which we said, okay, fine. So now we know where to file the lawsuit. We went ahead and filed a federal lawsuit in Virginia against National Students for Justice in Palestine and its parent organization, American Muslims for Palestine, which we are alleging, bouncing off the Boehm case, is just an alter ego for earlier incarnations, which were already found guilty for providing material support for Hamas. And so each of our ATA cases sort of expands the ATA and pushes it in other directions. We sued, for example, the Associated Press for buying images from Hamas, having known that these Hamas photographers were actually in bed with the terrorists for at least 5 years in advance. We sued UNRWA USA for providing material support and aid to Hamas. We sued Binance, the largest cryptocurrency exchange, for sending roughly $900 million in remittances to foreign terrorist organizations, including Hamas. We sued the Palestine Chronicle. The Palestine Chronicle is an American 501c3 that was actually paying a Hamas terrorist, Abdullah al-Jamal, to hold 3 hostages in his house.
I'm sorry, they
And
were paying
incredibly
him to
enough,
hold
in a lot of
them,
these cases,
or that they were paying him and he was holding them?
well, again, it's unclear exactly what the payments were for. They were sending him money while he was writing for them stories about the horrible conditions that he was in, and at the same time, he was holding hostages. We are definitely of the consideration that they were providing him support so that he was able to go on continuing to hold those hostages in his house.
Wow.
Certainly, they were providing material support to a terrorist who was engaging in an act of international terrorism
So
at
it
the
seems
time.
to me that at least in the cases that you've mentioned now, there's maybe some more clear-cut cases and others that might fall into a gray zone. Meaning, if UNRWA and Binance are funneling payments, that's one thing. And if, for instance, you're, sending out pamphlets, or I don't know, in some way advancing a message, potentially in the world's greatest bastion of free speech, that's another thing. So, um, presumably aiding and abetting by funneling financial support is something that's kind of been standard in terms of what brings about criminal liability.
You're 100% right, is that generally a lot of these cases, especially the early ATA cases, involved banks. Because when you think about providing material support, what comes to mind generally is money. And what courts are used to looking for are money trails, whether it's checks or invoices or
So how do you
receipts or
guard
whatever it
against
might be.
the free
Um,
expression issue? Number one, and like, what's the best case that advancing a message is aiding and abetting in the same kind of material support way that finance is?
sure. Again, the Supreme Court in Holder versus Humanitarian Law made it abundantly and absolutely clear that even speech, if it's done in coordination with and foreign terrorist organization like Hamas, for example, would be considered a form of material support, and that a reasonable person could tell whether it was advocacy done completely separate from a foreign terrorist organization or not. So let me give you an example from one of our cases, right? We sued the CUAD, Columbia University Apartheid and Divest, that's Mahmoud Khalil's group, for material support for terror. They have become one of the most effective propaganda arms for Palestinian terrorism. And by the way, just in terms of coordination, they even received explicit thanks from a PFLP terrorist on behalf of his, quote, friends and brothers in Hamas during an event that they hosted. It was called the Resistance 101 event at Columbia. And again, the nice thing to remember in these cases is that the useful idiots we're dealing with are also, at the end of the day, idiots, and they make idiot mistakes. So, for example, um, at the Columbia encampment that Khalil and his, co-conspirators organized and spoke for, his followers famously shouted, "We are all Hamas." And they identified the Jews on campus as Al-Qassam, that's Hamas's military wing, next target. And in September, they distributed recruitment flyers with literal messages from Hamas and PFLP leaders. And the booklet, this is the best part, explicitly stated, this is part of a, and I'm quoting, coordinated and intentional effort to uphold the principles of the resistance. Unless you were unsure what the resistance was, on the backside was pledges of oath to Hamas, the resistance, and the PFLP. Again, it's almost like they read the Holder case and said, how can we violate this and how can we put it in writing to make it clear to anybody that this is not separate advocacy, it is intentional and coordinated with an FDO. So again, I should just also mention, by the way, that beyond propaganda, the CUAD and these other, they also engage in conduct, right? Not speech in furtherance of the resistance. So, for example, they coordinated hostile takeovers that obstructed campus operations that resulted in illegal activity, including trespass, assault, vandalism, robbery, destruction of property, arson, criminal possession of weapons, burglary, false imprisonment,
That was
intimidation.
that was an
None of
impressive
those
laundry list
are
read at a
protected
very, very fast
First Amendment.
rate. I applaud you.
Sometimes when I talk, I'm in the South now, but
I
my
was
New
gonna
York
say, I'm
background
from
comes
New
out.
York,
Yeah.
and I
Again,
almost feel the need to stand up and applaud. Okay, so when you started, when you said, okay, they say that we're all Hamas, I almost wanted to ask, well, does some kind of emotional identification really take you as far as it needs to? And then you added everything else. I thought, all right, like probably shouldn't even ask the question anymore.
look, the
Yeah.
first line in our Virginia lawsuit is that when someone tells you who they are, believe them. When someone tells you, I'm trying to coordinate with a terrorist organization, it behooves us all to believe them. And I should also point out that the ATA is an attempt crime, right? So I'll give you a very interesting example. U.S. versus Osadzinski. There was this poor loser who was sitting in his basement trying to help ISIS. Turns out he was talking to Langley, the FBI, the entire time. And what was he doing? He was translating ISIS videos, and he was held liable because it's an attempt crime. He was trying to coordinate with Hamas. Again, in this instance, we have literal Hamas thanking them. They're saying you're welcome. We have instances where, the IRGC puts out a memo saying we want you to protest on April 15th, and they go ahead and they protest on April 15th. This is real, legitimate, real-time, not hidden coordination. And again, it's one thing if someone says we are Hamas, but if they say we are Hamas, and then they work with Hamas, and then they commit crimes in the name of Hamas, at some point you have to realize the
So,
First
okay.
Amendment simply
So,
doesn't
but the line
apply.
is coordination. Okay.
Mhm.
Now, you do have a bunch of other suits that you're pursuing. I mean, basically, maybe you should even talk for just a second about what the NJAC is and its mission. Because, I mean, the common theme to most everything you do is that you're trying to advance the protection of Jewish communities through the law. But you will do a better job of introducing it. And then I'd like to understand, especially in light of we had, in the past few months, I think, pretty recent stories about I think it was 70% of religious-based hate crimes in the States are directed at Jews. A 21% uptick in physical assaults, I think, even since between 23 and 24. So that's been like a dramatic uptick in the kinds of challenges that Jews are facing on and off campus in the States. These are things that you deal with. And so once you give us more of an understanding of NJC, I'd really like to understand, putting aside terrorism for a moment, how do you deal with these other kinds of issues of assault or harassment?
Taking a step back for a second, there are a number of great organizations working in this space trying to protect Jewish rights from a legal perspective. What makes NJAC a little bit different is the fact that what we were trying to do is really to expand the toolbox of available options to protect the Jewish community. And so we're trying things that haven't necessarily been tried before, and we're developing new and I hope innovative and successful theories to do that. And I'll give you a couple examples of what I mean. You may remember in June of 2024, there was a pogrom outside of Adas Torah Synagogue in Los Angeles. And, everybody said the right things. Jews were being beaten in the streets outside of a shul that was hosting an Aliyah event. Everyone from President Biden to the mayor of Los Angeles said this is a horrible act of antisemitism, completely against American values. And we waited, and no one did anything. Literally, nobody was indicted. So 30 days later, we filed a lawsuit, and we used something called the FACE Act. The FACE Act is the Freedom of Access to Clinic Entrances. It's usually an abortion clinic act, but in order to get it passed in the 90s, the Democrats made a deal with Republicans. They added a second clause, which nobody reads, which says, or houses of religious worship during an act of religious worship. And so we used that clause, which had never been used before in this way, to try and protect the synagogue from having a pogrom take place outside. Now, again, fascinating developments. We're moving, thank God, to trial against Code Pink, which is the group that organized, the hate group, I should say, that organized that particular riot and pogrom. But along the way, one of the arguments that they made was this is not a religious event. They're just learning how to buy property in Israel. It's just a real estate event. And so I believe this is the first time anyone has quoted the early Jewish commentator, the Rivash, in federal court. But we explained that no, not only is the commandment to make Aliyah and move to Israel something that the Talmud considers equal to all the other commandments in the entire Torah. In fact, Hechsher Aliyah, preparing to make Aliyah, according to some of these Rishonim, early commentators, is a partial fulfillment of that commandment and therefore an act of religious worship. And the judge basically said, I'm not touching that with a 10-foot pole. And so now Aliyah is protected as a First Amendment right in the United States for the first time. And I'm very proud to say that just a couple of weeks ago, the Department of Justice filed their own FACE Act case using the same principles, making the same arguments about Aliyah to protect against a pogrom/riot that happened at a similar event in New Jersey. So we're hopeful that the FACE Act now will become one of those tools that protect the Jewish community on a regular basis. And we have FACE Act cases developing in multiple jurisdictions across the country. That's an example of trying to. Yeah.
It's civil?
Yes. Well, there's both aspects, but we're using it civilly.
And then, in addition to the FACE Act, there was I think another ruling that you were.
Yeah, I'll give you another example of a way that we've expanded the toolbox, which is, um, again, interestingly enough, there is a another nexus between these two cases, which is Code Pink. Again, a vile hate group, but they were having a protest in Washington, D.C., and some Jewish supporters came to counter protest. One of them, our client, Kim Summerall, was wearing an Israeli flag around her neck, and one of these Code Pink protesters grabbed the flag and choked her with it. Um, should be, I think, a fairly obvious act of racially motivated anti-Semitic behavior, but the prosecutor and the judge said, choking a Jewish woman with an Israeli flag, they didn't see any signs of anti-Semitism, and we didn't want to let that stand. And so we filed the case, but we had to figure out the best way to do this that would also highlight the fact that it wasn't just a simple assault and battery. It was an assault and battery based on the person's identity, which should be protected. And so we used a law called Section 1981. It's part of the 1866 Civil Rights Act. Most people use this for contracts. It's known as a contract law because it mostly protects against contracts that discriminate on the basis of race. But there is a line all the way at the end which says, or security of person. And so we used that clause to say that they attacked her security of person based on a protected characteristic, her Jewish race. And we got what I believe from Judge Trevor McFadden, the strongest opinion since October 7th, where Judge McFadden said this is absolutely an overt act of anti-Semitism. Again, it is akin to yelling a racial slur, he said, and attacking a person of color, and it should not stand in the United States. Now, this caused a massive uproar on social media amongst the functionally illiterate. So, Marjorie Taylor Greene, for example, went on to Megyn Kelly's show and said something along the lines of, this judge just ruled that you're allowed to burn every flag, including the American flag, but not the Israeli flag. The only word she got right in that entire sentence was flag. So there was a lot of sort of noise and miscommunication about what this actually stood for. But what it really stands for is, again, another instance of Jews being protected under Section
Would that
1981. Now,
would that ruling apply if it were a non-Jew wearing the flag at a pro-Israel demonstration? I mean, how would that work? Because the attacker perhaps assumed that the person was a Jew, but didn't know.
that's a good question. It could apply. So taking a step back for a second, you might ask yourself, well, are Jews even a race in the first place, such that a law based on
I
racial
was gonna
identity
come in
should
next,
apply?
yeah.
And the answer is because yeah, and that's a great question, and it's the first question a lot of judges would ask, and the answer is, from a legal perspective, it really doesn't matter because what the law protects against is racial discrimination. So you might argue there's no such thing as race; it's entirely a social construct and no scientific evidence for it, or you might say that there is scientific evidence, but not for Jews to be a separate race. However you define race doesn't matter. It is clear, beyond a doubt, that historically Jews have experienced racial discrimination, meaning that people attack them because of a real or a perceived aspect of their race. Just think back to the Nuremberg laws, or even, unfortunately, in the United States, some of the early immigration laws which treated Jews separately on racial characteristics. So undoubtedly, Jews have experienced racial discrimination, which means that laws that protect against racial discrimination could in fact apply to them. And now, going back to your first question, if you attack someone because of a real or perceived aspect of their identity, that can also be protected, even if you were
And
wrong
so in
about that
practice, the
aspect.
Israeli flag has now been grouped into a category of traits.
It can be an indicator of Jewish identity. Anytime there's a hate crime or a bias motivated incident, right? Prosecutors and authorities have a
Mhm.
checklist that they look for. So, you attack a person of this background. Let's look at your Facebook posts and see whether or not you had a history of saying horrible things about that group, right? All of these standing alone, they're not much, but taken after or in light of an actual incident where a person acted on hate, they are evidence that the action was motivated by a biased factor.
And I mean, would you be aware of the fact that outside of DOJ, let's say more people are using the FACE Act or more people are taking the theory, related to 1981 and using it in court productively?
Yes. Yes, we know of at least 5 other Section 1901 cases, some of which have been filed, some of which are about to be filed using this theory. And, in terms of the FACE Act, it's interesting. We have 3 FACE Act cases developing, but we also are aware that there were at least 3 protests that were canceled after our ruling came out because they were going to commit FACE Act violations, and they saw that it would no longer pay. So we've created a bit of deterrence for people. Again, they can exercise their free speech. We're talking about violating the law. If you're planning to go and protest a stroll with reasonable time, place, and manner considerations, that's one thing. But if you're planning to block the entrances and engage in violent pogrom activity,
Mm.
that's another.
So, unfortunately, there are probably many more cases than there used to be of these kinds. How do you evaluate which ones you'll take and what has the most chances of success?
I would say that unfortunately, everything that we do is scalable. So there's obviously a resource component as to which cases we can take. But again, what we try to do is really think about the strategic impact of the litigation. So we are unlike law firms, general law firms, in two ways. Number one is we'd be absolutely fine going out of business. And in fact, it's something that we pray for on a regular basis. And number two is we don't take cases based on any kind of financial return or motivation. So I'll give you an example. The cases that we filed against groups like the Students for Justice in Palestine, these are just pass-through organizations that barely exist. What is the point of suing them if there's not going to be recovery? And the answer is the strategic impact of that litigation. And it's not just about SJP. So I don't know if you've ever been to any of these rallies, but I'll tell you something fascinating. If you go to one of these protests or these encampments and you walk towards the center, you'll notice something fascinating, which is that charitably, 90% of the people there could not tell you what river or what sea, right? They are there either for the pizza or because they have been genuinely misled into thinking that they are on the right side of history. Now, at the center, there's these 10% of extremists who you're never going to convert. But if you can get a court to explain to these kids that, hey, whether you realize it or not, you've actually been in bed with terrorists all this time, maybe you'll save 90% of our future congressmen, senators, or just, your fellow citizens or your children's classmates from accidentally engaging with terrorism and being completely brainwashed. So that's the kind of strategic impact that we're looking for, long-term things that will help the community, um, even if they're not necessarily, financially
In
viable or
theory,
important.
now that you've taken us back to Students for Justice in Palestine, but in theory, if you find that this group or any group, right, has violated the ATA prohibition on material support because of their advocacy of certain messages, in addition, in a coordinated way, does that trigger some kind of law enforcement response beyond the specific case?
It's not automatic, but it is hopefully correlative in the sense that it would hopefully happen
I mean,
immediately. There are some
I could
things that
ask
would
the
happen.
question in
So
a slightly different
they'd
way
lose
because
their.
I have followed some of these cases in the past, not specifically these lines of reasoning necessarily, but SJP has cropped up in the past. Westpac has cropped up in the past, and you can go on and find a whole series of other organizations where um, it seems that very troubling links exist, but they haven't really been cracked by even the problem itself overall has not yet been cracked.
Yeah, we are limited somewhat by the fact that all we can do is civil litigation. So, there are some times where we get information and that information is better off used by the IRS or the House Ways and Means Committee to go after a group's 501(c)(3) status. Or we might make a recommendation to the DOJ about a potential FARA violation. Or you might make a recommendation to the Treasury or State Departments about potential sanctions or designations of foreign terrorist organizations or again to the DOJ or to state AGs or whatever it might be.
And are those kinds of things being taken seriously now, and with a change between administrations?
Yes,
Mm.
yes, 100%. Yeah. Um, Again, anyone can set aside whatever politics they want. The Jewish community, I believe, owes a sincere debt of gratitude to the Trump administration for taking these concerns seriously in a way that they were not taken seriously before.
Now, just going back to the issue of speech, I'm kind of processing as we go through here. But going back to the issue of speech, uh, all right. So we've talked about coordination as a red line for what's permissible and what isn't. But perhaps there are, even within just the realm of speech itself, maybe there are things that really do cross a line. And if so, where is that? And would it matter, let's say, if you are like on a campus or in a school? Does that, time, place, and manner, does the place really influence when the line's been crossed?
Sure. I mean, the truth is, it's a great question because most people are not, in fact, material support for terror. It is the rare student group like SJP that we believe actually is. So in general, I think the question is, how does the First Amendment apply at the university level or at the school level? And the answer is the First Amendment is not a free pass to threaten, harass, intimidate, or otherwise violate anybody else's rights. It is true that freedom of speech, even offensive and hateful speech, should be protected, but there are limits to what constitutes speech, and there are rules for when it crosses over into actionable, unlawful conduct. Again, I mentioned it before, but the First Amendment doesn't protect, even without terrorism, trespassing, vandalism, harassment, assault, destruction of property, provision of doesn't protect speech that's not meant to inform or persuade, but just to disrupt lawful behaviors. So, for example, activities like going to the kosher dining hall or studying in a library, like happened at Cooper Union. So the First Amendment doesn't protect someone who's making true threats. Supreme Court in Virginia versus Black defined that as statements where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual or group of individuals. It doesn't protect intimidation, which is a type of true threat where the speaker is directing a threat to a person or group of persons with the intent of placing the victim in fear of bodily harm or death. And just in 2023, in summer of 2023, Counterman versus Colorado, the Supreme Court clarified that the intent standard for true threats is not that the person speaking even intended to threaten the victim. It's a recklessness standard. So again, what that means in our context, the First Amendment does not protect a person who consciously disregards a substantial risk that his or her communications would be viewed as threatening violence. It is beyond the pale to think that the people making the kind of threats they're making on campus don't understand that the Jewish students see these as threats of violence. Again, all of the above have occurred on American campuses over the last couple of years. But the problem here is somewhat more acute. So if you think back, for example, to the testimony of the congressional testimony for the presidents of these universities, where they were unable to condemn calls for genocide, it's because they were using the wrong standard. And let's take a step back. We said there's no First Amendment protection for speech that involves incitement. And the court, in a case called Brandenburg versus Ohio, said that includes speech that's directed to inciting or producing imminent lawless action, and that is likely to incite or produce such action. Brandenburg is very famously a very high standard, and that is where the universities were hiding, and that's where they got it. That's where they got it wrong. The truth is that, first of all, even the Brandenburg standard has clear applicable limits, right? Including reasonable time, place, and manner restrictions that have to be compatible with the normal activity of a particular time and place. So even under the Brandenburg paradigm, a student rally, for example, that disrupts the educational enterprise and the functioning of a school should be restricted by that school, and that would not offend the First Amendment. So rallies that are celebrating calls for anti-Semitic genocide, right, they arguably disrupt the educational enterprise and functioning of a school because they leave some students fearful for their lives. But again, that argument, which is what they were trying to have, whether or not these were incitement or not incitement, it's unnecessary because Brandenburg is the wrong standard for schools to be using. In a case called Tinker versus Des Moines, the Supreme Court found that the Constitution does allow schools in particular to shut down speech that will materially and substantially interfere with the requirements of appropriate discipline in the operation of the school or invade the rights of others. Now, by the way, of course, private colleges and universities can restrict speech and conduct in most cases without triggering any constitutional issues. But even a public university is not a public street, and the rules for which speech has to be allowed are each very different. You might ask, well, Tinker versus Des Moines was a K through 12 case. Does it apply to universities? Supreme Court said yes. Healy versus James, 1972. University officials can apply the same
You basically
framework. So,
provide like a litigation guidebook to anybody that actually decides to go through the entire episode here. And the basis for the added protections is just the purpose of a school and the safety of students. Is that
well, the basis is that students have a right to a safe and harassment-free environment, and that's a legitimate pedagogical concern. And under the Tinker line of cases, the schools don't even have to wait for the disruption to occur. This is the most interesting part, I think. A school can ban potentially disruptive expression if they can, quote, reasonably forecast that the speech in question would disrupt school discipline or operation. I'll give you an example. a case called Melton versus Young. The court ruled in favor of school officials who prohibited the wearing of a Confederate flag jacket. Why? Because it was reasonable to assume that a Confederate flag jacket would be disruptive in what they called an environment of heightened racial tension. Okay, in my opinion, and I think it's obvious, waving a Hamas flag and cheering on slaughter, right, even as those victims' bodies were still being recovered back in, October of 2023, while announcing solidarity like SJP did with their resistance movement and that armed struggle is legitimate, right? That's certainly no less likely to cause a disruption than wearing a Confederate jacket.
All right, so I have one question that doesn't deal with any specific case, but I wonder a lot. This is a personal struggle I have. Um, I wonder about how far we should be promoting limitations on speech. Now, it seems to me that many of the cases that you've talked about here are so clear cut, and it's not just speech usually. But born and bred in the U.S., I am something of an almost free speech absolutist, and it's always been one of the things that I appreciated most and admired most about the United States was that we had that unique to the entire world, including the state of Israel, but certainly places like the UK, where it's become increasingly dangerous to have even mainstream opinions. I might argue on a whole series of different issues, even those. So, I mean, how do you like? Where do you sit on that spectrum personally? If I could scratch beneath the surface, and how do
Sure.
you see these efforts
Yeah,
when measured against?
I'll tell you that. Sure. I'm a law professor by training. I'm a law professor at Turo Law School, and I absolutely and wholeheartedly agree with you that the First Amendment is part of what makes America incredible and a great nation. And I think it should be absolutely and wholeheartedly respected. I think it should be enforced entirely, including with its limitations. And so I think if there are gray area cases, we need to look very carefully to make sure that lines aren't being crossed. But the point is, we don't have that luxury because these are not gray area cases, right? Anytime that it's speech plus, it's even easier to talk about whether it's speech plus material support or speech plus incitement or speech plus two threats, etc. Um, I'll be the first to tell you that we turn down more cases than we take, many, many more cases than we take, because even if something is wrong and abhorrent, it doesn't mean that it's illegal. Let me be clear. Anybody in the United States is allowed to say whatever they want, however abhorrent, about Jews or the Jewish state. They just can't then act on that hatred and want to get away with it by claiming that that's also part of their free speech. So I'm with you. On the gray areas, I think we have to look very carefully, but unfortunately, we're not there.
Plenty of fodder for future conversations. Although, like you, I hope that or at least that you're out of business at some point soon, and that you can do other things. I wish you great success with the cases that you've taken on, and look forward to following developments. And thank you for your work.
Thank you.